Hi, I'm Daniel Findling with Findling Law and the Divorceguy.com. I'm going to do my best to try to summarize Michigan child custody law. Now, in many ways, child custody and parenting time have become synonymous. But custody is really made up of two parts: legal custody and physical custody. Legal custody defines major decisions related to the parents. It's usually joint. The parties share equally in decisions, such as healthcare, choice of school, domicile, whether or not you're going to be able to move more than 100 miles from your current residence or out of state. These major decisions are legal custody decisions, and like I said, in most cases, even when the children spend the majority of time with one parent, we see a joint legal custody arrangement. Now, when it comes to physical custody, that's really an older term of art. Sometimes we use the primary custodial parent or no words at all to define the frequency by which each parent spends with the child or the children, as the case may be. In cases of equal parenting time, we just may use the term joint custody. But in cases where one parent has the majority of parenting time, for example, let's say the non-custodial parent has every other weekend and one midweek of parenting time, we may still use the term joint custody, but describe the parenting time. In either case, whichever parent has the majority of parenting time under the old vernacular, that maybe the non-politically correct mechanism, would be considered the physical custodian of the child. Now, when there's a child custody dispute, it's really a three-pronged determination. Now, in modifications, you must first make a determination, that is, if there's an existing child custody order, has there been a change in circumstance, a material change of circumstance, since the entry of the last order that would warrant revisiting a child custody determination? We call that the Vodvarka versus Grassmeyer, which is the case, threshold requirements. You don't even go to step 2 unless you can show that there has been a change in circumstances. Now, if there's a new custody determination, or you've already met the threshold of proper cause or change of circumstance, the next step is there an established custodial environment? An established custodial environment means with which parent do the children or does the child look to for the regular necessities of life over an appreciable period of time. Now, if the children look to one parent, it has legal ramifications. Whereas if the children look to both parents, the ramifications are very different. If there is an established custodial environment with one parent, that is, the children look to one parent for the regular necessities of life over an appreciable period of time. Let's say, for an example, you've separated and the children remained with the mother and 3 or 4 months have gone by. In that instance, it's very likely that the mother would have an established custodial environment with the children, or the child as the case may be, because he or she looks to that individual, the mother, for the regular necessities of life, in this example, over an appreciable period of time, over several months. On the other hand, if you're living together and maybe mom is working and dad's staying home, and dad says, well, I have an established custodial environment. No, you may, in that instance, maybe both parents have an established custodial environment because there's different needs that are being fulfilled. Some of the needs of the children are being met by the other parent working, while another parent is staying at home, maybe cooking and cleaning and doing the things that a stay-at-home parent would do. Now, if there is an established custodial environment with one parent, the burden of proof is clear and convincing evidence. That's the second highest burden of proof that Michigan law provides. That means, in plain language, that it's very difficult to remove a child from an established custodial environment. In fact, a court will not do it unless we can show by clear and convincing evidence, which is almost beyond a reasonable doubt, but not that high, a little bit lower, but certainly more than preponderance of the evidence. There must be clear and convincing evidence that it's in the best interest of the child or the children, as the case may be, to remove them from that established custodial environment into a new environment. So if there is an established custodial environment with one parent, in plain meaning, it means that it's difficult to remove that child or the children because the burden of proof is clear and convincing evidence. On the other hand, if there's an established custodial environment with both parents, Then the burden of proof is what we call preponderance of the evidence, sort of like the scales of justice. Do the best interests of the child favor one parent or the other parent? Now, when it comes to the best interests of the child factors, which is the third step in this example of child custody, there are 12 child custody factors. On the website, of course, you can review all 12, but let me summarize some of them. The love, affection, and existing emotional ties between the parent and the child. Which parent would offer permanence of a family unit? The ability of the parties to foster and encourage a good parent-child relationship with the non-custodial parent. The moral fitness of the parties. The ability of the parties to raise the child in their race, religion, and creed. These 12 factors, domestic violence is a factor, and then there's a catch-all, any other factor that the court may deem relevant, instructs the court how to examine with which parent the child or the children should be with. That's the best interest of the child factors. Now, these 12 factors, what the established custodial environment says is how much do we have to prove these factors. Now, it's important to note, although there are 12 factors, they don't necessarily all have to be weighed equally. In some circumstances, maybe the love and affection and existing emotional ties between the parent and the child is the most important. In many cases, it's the ability of the parties to to encourage and maintain a good parent-child relationship with the non-custodial parent, not disparaging your spouse or your former spouse, or the mother or the father, as the case may be, is the most important factor. All 12 factors have to be considered, but it's not as if you add up and say, okay, I have 7, you have 5, I win. Because if one factor has a lot of weight because of the facts and circumstances in the case, maybe an obvious example is one parent is equal on every factor except, or maybe even excels on every factor except his or her health. Right? Maybe they've suffered a physical or mental trauma that prevents them or impairs their ability to parent. That one factor may be so paramount that it outweighs the other factors. So in sum, when we look at child custody, we'll try to wrap things up here. We're talking about legal custody, major decisions regarding the child or the children's welfare, and then we're talking about parenting time, or the amount and frequency of time that parents spend with the child. We used to call that physical custody. In evaluating custody, we look at the best interest of the child factors, these 12 factors I just discussed. However, if you're trying to modify custody, you must first show that there's a change in circumstance or proper cause, and then we establish the burden of proof with the established custodial environment. There's a lot of information here. I hope I didn't confuse you too much. Of course, you're welcome to call us at any time at 877-YOUR-FIRM or 248-399-3300. Visit us on thedivorceguy.com as well. I'm Daniel Findling with Findling Law. Thank you for your time. It's my hope that I've helped you at least provide a little bit of comfort and guidance as it relates to child custody in Michigan.